Hello everyone, welcome to Business Law Lecture 11. Now our subject to discuss is about consideration in a contract. The consideration, does this happen because after the intention to create legal relations, offer and acceptance, the third essential condition for the creation of a valid contract, it's called consideration. You can see the module or PPT material that I have shared with you and follow through this PPT together um, with this video. The video will give you more chance to learn on your own pace how this subject being discussed, and you can read through or watch through on your own time. Consideration then has been defined as some value or benefit that must be given or promised by one party in return for the other party's promise. It is like there must be something for something. Yeah, for an exchange of value. Yeah, so for example, if X says to Y, I will give you 100, and Y says thank you. So there is clearly an agreement, but it is not legally enforceable, meaning this is not a legal contract. In this case, not only is there possibly no intention to create legal relations, but also Y has given no consideration to support X promise. X promise remain gratuitous and supported by consideration. If instead, in addition to saying to Y, I will give you $100, X writes, I solemnly swear to pay Y $100, and even if Y writes underneath, I agree, there is still no agreement legally enforceable by Y because Y has still done nothing. X promise remain unsupported by consideration. So consideration can be viewed as price, and the common law requires a price to be paid for every promise before that promise will be legally enforceable. Mutual promise, this happens when A promises to work for B, and in return for B's promise to pay A. A promise in return for an act where A promised to pay B for certain work in the future by B, B then carries out of the work is B's consideration for A's promise. In the case A says to B, if you buy a yacht from money due to you on your 21st birthday, I will buy you a trailer for the yacht for your birthday. B then buys the yacht, which is his act in consideration for A's promise, A's debts. C agrees to act as A's attorney in consideration of B's promise to pay A's debt. A promises B a yacht for his 21st birthday. In anticipation, B buys a trailer for it. B acts it's not consideration for A's promise. So B promised neither A nor anyone else anything in return. So on page A, there's rules of consideration. There are some rules set up regarding consideration. The first one, consideration is necessary to the validity of every simple contract. It is necessary in all simple contract to make a legally binding promise. In the case of Ron and versus Hughes on page 9, In this case, Mrs. H, the administrator of an estate, made a promise in writing to pay out some money to Run. There was nothing given or promised by R, the person to whom the promise was made, and therefore, which is Mr. Ran, Mr. Ran, yeah, and therefore there was no consideration for her promise, yeah, the person who, okay, Mrs. Yeah, it was held that all contracts are by law amount to a consideration must be proved. Accordingly, R did not succeed in his action against Mrs. H, Mr. Run, and Mrs. Hughes. Yeah. The second one, consideration can be present or executed, or future or executory, but not the past. Consideration is said to be executory or performed or accomplished when the plaintiff has given a promise in exchange for the defendant's promise. C then may agree with R to purchase a piece of furniture from R. This then delivery to be made by R within 7 days. The payment made by C within 30 days. So a contract has been made, performance of which by both parties lies in the future. The consideration in this situation is said to be executory or the future. Yeah, consideration is said to be executed when the plaintiff perform an act in an exchange for the defendant's promise. So the reward situation where the lost dog is returned in response to the advertisement last I previously shared with you is an instance in which the consideration for the promise is executed. Um, so what happened to past consideration? It is called past consideration when there is no consideration at all and it is not recognized by the law. Consideration is said to be past when the promise is made subsequent following to the act relied on by the plaintiff and independently of it, where a person returns a lost dog before the owner is aware of that it is missing and the owner afterwards promises to pay the finder something for his trouble. The owner then is not liable on that promise. In those circumstances, the act of returning the lost dog was not in any way dependent upon or relate to the promise of payment which was subsequently made. Therefore, the finder cannot rely on performance of their act as consideration for the promise. You can see this case on page 13, Roscorla versus Thomas. You can look at if in the textbook as well. R purchased a horse from T, and T, after the sale has been completed, promised R that the horse was sound, good, firm, reliable. In fact, it was a vicious or nasty or brutal horse. The court held that the warranty that the horse was sound and not vicious was not binding on the defendant as the promise had to be regarded as being independent of the sale. So the transaction had been completed prior to or before to the making of the promise. Then the previous transaction amounted to the a past consideration and as such was not recognized by the court. In the case of Anderson versus Glass, you can see there's where an employer promised to pay an employee an increased salary, not only as to the future, but retrospectively to an earlier date. The employee could not recover to the increase in respect of the past period, as that part of the promise is that upon a past consideration. It should be executory or of the future. So, third issue regarding consideration is that it must be something moving from the person to whom the promise is made. So the qualification of this rule, it is used to be taught that this rule means that a party could not sue to enforce a contractual promise unless he had supplied at least part of the consideration given for the promise. This means that if A made a promise to both X and Y jointly that A would make certain payments to them in consideration of Y's promise to do certain work for A, X could not enforce A's promise to pay as he had not profited any of the consideration given for it. So, in the case of Dunlop Pneumatic Tire Corporation versus Selfridge Corporation Limited on page 16, the Dunlop Company, who has manufacturers of motor tires, sold them through agents or distributor under a price maintenance agreement. That is to say that the agent agreed that they would not sell the tires at less than the retail prices advertised in Dunlop list, and would obtain similar undertaking for any retailers to whom they sold the tires. One of their agents, Dew and Co., sold Dunlop tires to Selfridges, and they contracted with Dew and Co. that they will not sell tires to a customers at least than the list prices. So Selfridges, in breach of the contract, sold tires to customer at less than the list prices, and Dunlop brought an action against them. The action was unsuccessful as the parties to the second contract were Dew and Co. and Selfridges. Dunlop then could not sue on a contract to which they were not a party, and no consideration had moved from them. On the issue number 4 or fourth issue regarding consideration, it need not be adequate or commercially realistic. This has happened then when the adequacy of the consideration is for the parties to consider at the time of making their agreement, not for the court when it is sought to be enforced. If, for example, a person gets what they bargain for, the court will not trouble about what they give in return, as it is for the parties themselves to decide what is adequate at the time of making the agreement. So, however, the consideration must have some value in the eyes of the law. It must be sufficient. Whether the parties enter into a poor deal or not does not concern the law, because consideration need not be adequate as long as there is at least some consideration present. Good consideration to support a simple contract at common law can be nominal or trivial or unimportant or small. It can be real and substantial. It need not be at commercial rates. However, it must be sufficient or enough or satisfactory, and this means that it must have some legal value. Remember the rule that the adequacy of the consideration is for the parties to consider at the time of making their agreement. Or if a person get what they bargain for, the court will not trouble about what they give in returns. The law leaves the parties free to make their own bargain, and the validity of a contract is not affected by a bad bargain. An example on page 20, you can see the case where I will give you my old car if you tow it away. This can become enforceable because of the detriment or loss or disadvantage suffered by the promisee. The next issue regarding the consideration, which is number 5, is consideration must be sufficient. So the adequacy and sufficiency of consideration are not the same. The concept of sufficiency raises the question of whether an act is consideration at all. For example, when a consideration lacks sufficiency and has no value in the eyes of the law, this is only happens when, first, performance of a public duty imposed by law. Second, performance of duty already imposed by contract. Third, moral obligation. The first, insufficiency of consideration because of performance of a public duty imposed by law. In this case, the duty which a person is obligated by law to perform is no consideration for a promise made in exchange for that performance. For example, a person obligated to attend court as a witness cannot sue on a promise of payment for his attendance, because such attendance is a requirement imposed by law, a promise of remuneration for, so attending is a promise made without consideration offer. Only if the promise does more than is required by public duty owed by law can the promisee sue for the amount promised, because only then does the promisee have something to offer. Let's take a look the case on page 24. Glassbrook Bros Limited versus Glamorgan County Council. During a miners' strike in South Wales in 1921, the colliery or coal mine manager applied for police protection and insisted that the police provide a live-in or statutory or fixed guard. The police superintendent, who thought that a statutory guard would be sufficient, finally agreed to the manager request provided the colliery or the coal mine pay £2,200 sterling for provisioning the force and for its service at the rate specified. After order was restored, the colliery refused to pay, and when sued by the police, argued that its promise to pay was not supported by any consideration, as the police were merely doing what they were legally bound to do. This agreement was rejected and judgment given for the police, recognizing that the police were bound to give protection. The court then felt that the reform of protection should be at the discretion, judgment, freedom of choice of the police, and that the provision or condition or term of more than the police superintendent or inspector or controller felt necessary provided sufficient consideration to support the colliery manager promise to pay the agreed £2,200 sterling to the police. The second issue is regarding the insufficiency of consideration related to duty already imposed by the contract. A promise to perform a duty already imposed by contract cannot constitute a good consideration. Let's see on page 26, the case between Stilk versus Myricks. In this case, an action was brought for seamen's wages on a voyage from London to the Baltic and back. Two seamen deserted or left, and the captain being unable to find substitutes, promised to divide the wages amongst the remaining 9 members of the crew if they completed the voyage. The court held that the captain's promise was not enforceable because it was not supported by consideration. Then the crew who were already contractual obligated to sail and to cover any emergency. According one sailor's claims against the captain for the extra wages failed, the court held that the agreement is void for want of consideration. There was no consideration for the pay promised to the mariners who remained with the ship. Before they sailed from London, they had undertaken to do all they could under the emergencies of the voyage. They had sold all their services till the voyage should be completed. Those who remain are bound by the terms of their original contract. However, if the initial contractual duty is exceeded by something extra being offered, this might constitute good consideration under the old contract or form consideration for a new contract. Let's say the case of Hartley versus Ponsonby on page 28. Hey, H should be Mr. Captain of a ship. The proper complement or balance or number of men was 36, and while the ship was in Port Phillip, 17 of the crew members refused to work, leaving the remaining 19. In order to induce the remaining 19 members of the crew, P promised to pay H an additional $40 in return for H assisting in taking the ship from Port Phillip to Mumbai or Bombay, it's called Mumbai now, with a crew of only 19 hands. In this case, Hartley versus Ponsonby, the seaman's action was successful because the trial jury held that it was unreasonable for a vessel of that tonnage to carry a crew of only 19 hands. Without its full complement, the ship was found to be unseaworthy, and accordingly all seamen was discharged from their original contracts. It was held that the agreement to sail an unseaworthy ship could make up good consideration. The undertaking to continue the voyage with the reduced crew was held to be consideration for the captain's promise. The third issue is about moral obligation. The expression good consideration is something used to refer to that motivation or sense of obligation which might arise out of the natural love and affection within a family. Such motivation may, for example, lead a parent to promise to make certain payments to or on behalf of their children. Such motivation, no matter how morally defensible or valid it might be, does not of itself constitute a valuable consideration. Let's look at the case of Eastwood versus Kenyon on page 31. Eastwood was the guardian of the infant, Miss Sarah. He voluntarily incurred certain expense on her education and on the improvement of her estate. Miss Sarah, when she came of age, assented or agreed to the transactions and promised to reimburse E. After her marriage to K, her husband also promised to pay and he was sued upon this promise. E's counsel relied on the moral obligation to honor the promise made, but the action failed. The court held that there was no consideration to support D's promise to pay since moral obligation to pay was not recognized. So the consideration cannot be too vague or unclear. If the promise alleged as consideration is so vague and uncertain that it will not be enforced by the court, it will not constitute consideration. In the case of White versus Bluth, on page 32, a son's claim that his father had promised to discharge or free or release the son from liability. Can you imagine that? Or legal responsibility in consideration of the son's promising that he would cease from complaining to his father that the son had not enjoyed the advantages conferred on or give his brothers. So the court held that the son's promise not to board his father was too vague to form a legally recognized consideration for the father's promise. So, in conclusion regarding the rules of consideration that you need to remember, first one, it is necessary in all simple contract. It is required for a legally binding promise. The second thing, it can be present or future, but not past. The third one, it must come from the promisee, but need not move to the promisor. The fourth one, it need not be adequate or commercially realistic. Fifth, consideration must be sufficient. And last but not least, consideration cannot be too vague or unclear. Thank you very much. I hope you enjoy the this subject on consideration, and looking forward to see you in the next meeting. Thank you for having me. I hope you have a healthy life and happy stay wherever you are now. See you next time.